originally set for sentencing. I have received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz, and she did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes, and they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Claire on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over and she wasn't scheduled to do a test today, so she did not test. She did do her download of her SCRAM. I just confirmed with them that there was no violations on the SCRAM. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the SCRAM. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing order.
Why?
Why what?
Why'd you miss a test? I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh. They do so much. I mean, I didn't send you the last time. I'll re-refer to defendant to Von Schwartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't want to.
Paper?
What?
The paper?
What?
All the lists on it? What is Von Schwartz?
That's for your alcohol screening and assessment.
Is there somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for bond violation. Defendant remanded. Just go. Is that Dad?
Yes, Your Honor.
Get her back. Dad, hang on one second. Go ahead, take her back. Come on up to the, can you come up to the phone? What's your name, sir?
Tony Johnson.
Okay. Can you help try to get her through the, I mean,
Yes, I will definitely make sure that she does it. She lives with her mom, so I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I
she
know,
need this job so bad.
I know. And I, trust me, I did not want to. I just, Miss Polera, can you give to Dad the Von Swartz information and the victim's impact information so that he has it, so that I get where he is. So that he knows what she has to do.
Yes, Your
So
Honor. I do know, I heard him in the hallway, really getting after her for not doing things. So I think that he will.
Well, I don't doubt
If
that.
you stop by my office, or I'll ask them to give you the paper printed out.
And is that in this
It's
building?
right down the hallway.
Okay.
And so I'll tell them you're coming right down.
And,
Okay.
I have the $75 for any fee or whatever that she might have needed to pay. I do have the money, so.
Whose case is this? Yours?
What we just witnessed is a textbook example of how probation violations escalate, not because of one big mistake, but because of repeated misresponsibilities after clear judicial warnings. From the very start, this hearing was not meant to be punitive. It was scheduled as a sentencing review, with the court already having shown significant leniency months earlier. Back in April, the judge made expectations crystal clear. Do not miss tests, complete the alcohol screening, stay compliant. That warning mattered, because once a judge places that expectation on the record, the margin for excuses becomes extremely thin. Here's the key legal issue: compliance, not intent, not excuses. Courts don't measure probation success by whether someone meant to comply. They measure it by whether compliance actually happened. And in this case, it didn't. The defendant missed a test, failed to complete the alcohol screening and assessment, and did not follow up properly with community corrections after June 15th. Even though the SCRAM device showed no alcohol violations, that alone is not enough. Monitoring is only one condition. Reporting, testing, and completing court-ordered programs are equally mandatory. The judge's frustration didn't come from anger. It came from limitation. Judges cannot keep issuing warnings without consequences, because doing so undermines the authority of the court and the integrity of probation itself. When the defendant admitted she forgot to print it out, that explanation simply didn't meet the legal threshold required to avoid consequences, especially after repeated reminders, emails, packets, and prior warnings. This is also where the emotional weight of the case becomes undeniable. The father stepping forward wasn't scripted. That was real. A parent trying to intervene to salvage employment, stability, and opportunity for his child. The judge acknowledged that pain, even stated clearly she did not want to send her to jail. But judges don't rule based on sympathy alone. They rule based on compliance, history, and what options remain. And at that point, the court was left with very few. The defendant had already been warned that continued noncompliance could lead to maximum sentencing or contempt. So instead, the judge issued a short remand, 3 days in county jail, not as maximum punishment, but as a consequence meant to reset accountability. This was not about revenge or humiliation. This was about enforcing court authority before the situation escalates further. Legally speaking, this ruling sends a powerful message. Probation is not passive. It is active, structured, and time-sensitive. Missing steps, even administrative ones, can carry serious consequences. Employment concerns, while important, do not override court orders unless compliance is already demonstrated. Now, here's the real question for you watching. Did the judge do the right thing, or should one more extension have been granted? At what point does personal responsibility outweigh second chances? And if warnings don't lead to action, what options should a judge realistically have left? This case is a reminder that the courtroom isn't just about punishment. It's about accountability, structure, and follow through. And sometimes, even a judge who wants to help is forced to act when promises replace progress. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next one.